Good evening, everyone. We will get started here momentarily.
Good evening.
Good evening, everyone. We're just waiting to get a full quorum of members here, and then we will be able to get started. And while we're in the process of waiting for some of our colleagues to join, it looks like we've got looks like we're going to have a quorum of the planning board joining us, including one of the members who at the moment is on both boards. So for those of you on the planning board, congratulations. You are truly going to be getting another great member in Kevin joining the planning board.
I think we're all of us on the planning board are excited for Kevin to come on board, and glad to hear he has your endorsement.
Absolutely. Need one more member. Okay. We've got 5 members. We now have a quorum. As we get started here, if I can request someone to take minutes, one of the members. Catherine, are you available to take minutes last time? You did a fantastic job at our last meeting.
I can do it.
Thank you, much appreciated. And is recovering from some things, so has requested that another person take that duty. You did a fantastic job. Now that we're in an open meeting, I can absolutely say that, because it's definitely the case. We'll be talking about the minutes momentarily. So with that, call the meeting to order at 7:03. welcome everyone. Meeting of the Bylaw Review Committee. We've got a few things on the agenda. First is public engagement. If anyone from the public wishes to speak before we get into any of the specific items, you're welcome to do so. Otherwise, you will be welcome to join in.
Wow.
Okay, looks like that. Thank you for taking care of that. Otherwise, we will have open conversation during the main discussion itself, talking about zoning language and process. So if anyone would like to have public engagement at this time, you're welcome to indicate by raising your hand or otherwise speaking. Otherwise, we will move on to the approval of the minutes themselves. Seeing none, that brings us to the minutes from our last meeting, April 3rd, 2023. Reason that there was only one meeting in April was that the third Monday in April also corresponded with a state holiday. So with that being a state holiday, we did not meet. So the last meeting was April 3rd. Catherine took minutes of that. Those have been distributed to the committee members. With that, do we have a motion to approve the minutes as presented, and then we'll have discussion on the minutes themselves.
So moved.
So Anne has made the motion. Do we have a second?
Second.
Seconded by Tim. Catherine, you've got it? Excellent. Okay, so a motion's been made by Anne, seconded by Tim to approve the minutes as presented. I've already stated my opinion that the minutes met the required elements of having who was at the meeting, when it was started, when it was finished. All of the votes were taken by roll call and substantial summary of all the items discussed. Any other feedback, any other comments on the minutes, corrections, other things before we approve them? With that, all in favor of approving the minutes, we will need to take this vote by roll call for those members. So I will call in the order in which you see on my screen. Joe.
Yes.
Anne.
Yes.
Catherine.
Yes.
Tim.
Yes.
Kevin, welcome.
Yes.
Yes, and myself, yes. Kevin joined at 7:05. If you can record that, Catherine. So Kevin, what you did miss as we were getting started is I was singing your praises to your now fellow planning board members as you get to join that board as well, as you have tremendous overlap between them, and they are very lucky to have you serving, and the whole town is lucky to have you serving in that capacity. So I appreciate that.
Thank
So
you.
So with that, we've now approved the minutes of April 3rd. I will go ahead and mark them as approved and then send them off to the town clerk, and a copy goes to the town clerk, a copy also goes to the town administrator's office for posting on the website as per the other bylaws. Item number 4 is an administrative item. As per our bylaws, I forget the exact sections it's in chapter 9. That after the first meeting after the town election, we need to have a vote for chair and possible vice chair. That is the requirement. And so this is required of all terms that are greater than 1 year. So for all boards, this is the mandatory time for an election. It can also be called at any other time by several members. So with that, there is no prohibition on or requirement to have a change of chair. It can be done if anyone would like to, take over as chair and take those duties on in the administrative tasks. By all means, I'm not saying that someone else can't do it. I also have no problems continuing in the role should someone want me to do that. So with that, for the members' discussion and nomination.
I would like to nominate Dan Lieber for chair because I cannot even imagine you not being chair, Dan, nor anyone else wanting it. You do a fabulous job. So I'm nominating you for chair.
Thank you. Okay, so Anne has made a nomination. Is there a second?
Second.
Seconded by Tim. Further discussion? Kevin, sure you don't want to be chair and, try to then take chair of multiple things?
I think this is all you.
We have to have fun where you've got a quorum of both boards here at the moment. Okay, with that, we've got a motion on table to nominate myself as chair. Motion made by Ann, seconded by Tim. Any further discussion? With that, we'll take a roll call vote in the order in which you appear on my screen. Ann,
Yes.
Catherine,
Yes.
Joe,
Yes.
Tim,
Yes.
Kevin,
Yes,
and I will vote in the affirmative. Thank you very much. I appreciate the vote of confidence as well. So with that, vice chair, which is very helpful, especially for those times that I'm unavailable and for assistance. Anne has been doing a fantastic job of that. If there's anyone else that would like to take on that role, I'm quite confident that, we can certainly share the duties as well. Otherwise, I'm going to take it upon myself to nominate Ann Santos for vice chair and to continue in that role.
I
Is there-
second that.
Catherine seconds that very, very quickly. Okay. Other discussion? Joe, you could take on, the full leadership here and then also do it at ZBA and have absolutely no time for life.
No, thanks.
Figured I'd throw it out there.
Yeah.
Okay, any further discussion? With that, we've got a motion for to nominate Ann Santos as vice chair. Made and seconded. So with that, we will take votes in the order in which you appear on the screen. Joe,
Yes.
Ann,
Yes.
Catherine,
Yes.
Tim,
Yes.
Kevin,
yes,
and myself affirmative and unanimous. Congratulations, Ann. You get to continue your service as vice chair. You can't get out of it that easily. It was 9 years on the Board of Selectmen is town council, and well, hopefully this won't be 9 years, but you get to continue your service. Thank you very much. Okay, with that, the next item that we have for the majority of the meeting is the reviewing of the bylaws themselves. And with that, posted to our website is a suggestion of one section of bylaws by attorney Mark Bobrowski, who is again joining us from Concord, I believe. And that as an example, the purpose of tonight's discussion is really to go over all of the language and procedures for land use related purposes. So this is everything from enforcement, special permits, site plan review, variances, nonconformities. And the language that was sent over was taking some of our existing bylaws and rewording them into a new proposed codification with some changes and feedback. So with that, Attorney Bobrowski, if you'd like to take the floor, and we've got
Thank you, Mr.
a
Chairman.
variety of people here as well.
Great. Thank you and welcome, everybody. This is a meeting about job descriptions. So everybody's role is going to be discussed. That means special permit granting authority, ZBA as the variance authority, site plan review, the building department and its issuance of permits and certificates of occupancy. And just for fun, because there's not enough to talk about, I always throw nonconformities, the black hole of the zoning act, into a meeting with the same topic. So I'm going to ask if I can share screen, Mr. Chairman, and I'm going to put up section 1, and then I'll do section 5, and then I'll do section 10. So you were promised that I would color code new language. I always use yellow. If it's strikeout, then that's from your existing bylaw. And host disabled attendees screen sharing.
You're now co-host, so you have the ability to share.
Okay, great.
And I must say, if you're finding nonconformities to be fun, This is a most amusing form of fun.
Well, I was once lauded in the Concord Journal for making our
And it looks like Mr. Bobrowski may have just lost his internet connection. He should be joining us back momentarily. So we have 17 people who have joined us, much appreciated. So I know we've got members of the zoning board of the zoning board of appeals, along with planning board. So just one, as well as other professionals, much appreciated to have each of you joining us, because this is the beginning of a really important set of topics.
Can I ask a question while we're waiting?
Sure.
And this, I'm really glad we're starting in this manner. And I just wanted to get a little sense of timing. It seems like we have suggested edits to non-conforming uses, so we may be able to, I think, by and large, maybe resolve those if there aren't a lot of, if there's not much disagreement about that. But in terms of the other elements being discussed, it seems like that process is to have a bit of an open discussion, and then we would expect suggested language from Mark.
I got
And that-
bounced. But I am back.
Great.
You are back. Excellent. So Theo Noel, the chair of the planning board, just had some really interesting comments. Theo, if you can remake those, I think Mr. Attorney Bobrowski would appreciate those as well.
Sure. I was just trying to get a sense of sort of process and timing. It seems like with the non-conforming uses, those edits, that the rewrite, it's great to have that in front of us, and it seems like we'll probably be able to put those to bed if people don't have substantive changes. But with the other topics being discussed, is the idea to have a bit of an open discussion, which would then lead to future suggested corrected language, and then to be able to have additional comment on those language changes. Is that?
Well, the way that certainly nothing that I'm showing you is a final product. It's just
Right.
suggestions on my part that are certainly designed to give you something to think about, but also to use if you find useful. This is just a theme meeting on section 1, 5, and 10. There will be a first draft and you'll see it again. There'll be a second draft and you'll see it again. There'll be a workshop meeting and you'll see it again. And so you'll be so tired of reading section 1, 5, and 10 by the time we get through 6 more meetings where they're all back on the table that you'll wish you never volunteered. So
Not at all.
So section 1 is the handshake of the bylaw. And did I manage to get that onto the screen yet?
And Jim, did you have a comment while Attorney Bobrowski is setting up the screen share?
I had a question. Attorney Bobrowski mentioned sections 1, 5, and 10 from the planning board. I know that we're in receipt of section 5, that draft. Is there a draft 1 and 10, Attorney Bobrowski, or is that going to happen after this conversation?
So we are working our way towards a first draft, which will have changes in, but not just renumbering. after the meeting at which we discussed the first draft, there'll be a second draft with everything in, including the renumbered sections that don't have major changes to them. And then after that, we usually think about setting up a workshop where we invite stakeholders and seek comments from them so that we can further work on the bylaw with those comments having been given to us. So there's, I mean, the last time I did a town your size, we went to at least 10 drafts, and it gets much easier and smaller revisions when you get to draft 6, 7, 8, 9, and 10. But that's generally the process. I think in Medford, which I did last year, we went probably into in the teens, mid-teens, 14, 15 drafts. Haverhill took a few years to do it, and I think we were on draft 18 when they did it. So my function is to get you to the finish line. I don't care if it takes 18 drafts.
I guess that's not the nature of the question is that, so I have a printed copy of draft section 5, which I understand that you went through and rewrote. You mentioned sections 1 and 10 as well.
Right.
Is there a draft of that right now that's been issued to the town, or is that the purpose of this meeting to give the information such that you can then go and create that first draft of those 2 sections?
It's the latter.
Okay, thank you.
Yeah. I'm having a lot of trouble with Zoom. It's just not being good to me.
I just made you a co-host again with the rejoining. So now it should allow for you to share.
Okay.
And while you're setting that up, Bill, at some point you may want to be aware of traffic, because it does look like you are sitting in the middle of the street with your background. Just saying.
Understood. Yeah, there's usually some guys crossing behind me, so it's not as bad.
And if Attorney Grabowski wants to send the document to one of us, we could take over the sharing if that's easier.
I'm about to do that. Yeah, this blew up on me when I was away, and I haven't had a chance to take it into the office and have somebody smarter than me fix it. So why don't I just send you an email so that we don't waste any time? Who should I send this to? Dan, you want me to send it to you?
That works.
Okay. There you go.
Okay.
So
Thank you.
if you'll be kind enough to put up section 1.
I'm gonna grab them all so we can do that.
So this is, I just talk while you're getting it set up. This is, this is for the most part, it's boilerplate. You can see what you had, for example, for the purpose clause, just a word or two about to protect and conserve the value of property, which was in your existing bylaw, in the 3rd line, strike out at the bottom of page 1.
And
That-
I'm just setting it up right now. Here we
Okay.
go.
If you take a look down at if you enlarge it a little bit and look at the bottom where there's strikeout. That's great. You'll see protect and conserve the value of property. This section is not intended to be dangerous, but it can be. So in the last 5 or 10 years in the law of standing, there have been cases from our high court, Supreme Judicial Court, that say that diminution in property value is not an interest protected by zoning, and that diminution in property value, while you might claim standing based on that loss, you basically have to tether, words of the court, the loss of property value to another zoning related injury like traffic or noise or lights. So the thinking of the court is that the traffic is so bad at your house that the property is diminished in value. That would work, but you can't just say my house is diminished in value. You used to be able to do that until a case from Andover called Standerwick. That was a 40B case. And then in 2010, the court decided Kenner versus Board of Appeals of Chatham. And the same proposition was switched over to 40A, the Zoning Act. So there are actually cases still, and Kenner was such a case, in which the bylaw said to preserve the value of property. And the court made it very clear in Kenner, even when the bylaw said that was a protected interest, one of the purposes listed in the Chatham bylaw, that you still had to tether it to something. And so this is an incredibly complicated fight in every zoning appeal. Whether the appellant has standing is a prerequisite. You cannot bring a lawsuit to challenge a special permit or a variance or a building permit or site plan approval if you don't have standing. And consequently, you'll see in the purposes in yellow in section 1.2 that I did not repeat to protect the value or to protect and conserve the value of property. It's out of respect for the Supreme Judicial Court's decision that should not be construed to be a locally protected interest. Another good example is view. View is not a protected interest under the state law, but if you say that view is a protected interest in your local bylaw, then you can get standing by claiming a disruption of view. And you have to think twice about whether you want to do that because standing is everything in a zoning appeal. The rest of these,
So just to put that in perspective, would that be, what comes to mind is Amesbury, where they actually have a different tax rate for view. So people who live along the river, I believe, have a higher tax rate. So would that be it? If we were to have a different tax rate, people who, just for the sake of discussion, had a view of Lake Quantapowhat or Crystal Lake, is that when view might be relevant? Right now, we don't have a different tax rate, and I'm not proposing that we do. I'm just trying to understand when that could be relevant.
well, the lead case is a Plymouth case, Monk versus Board of Appeals of Plymouth. And the Plymouth bylaw said that view was a protected interest. So in determining whether the special permit should be granted, one of the factors to consider was view. And where it's called out like that, it's a protected interest under the local bylaw. So view is something that has to have that kind of a mention in the bylaw. Even if you mention diminution in property value and try to protect it as a local interest, my read of the Supreme Judicial Court's cases is that it isn't going to work. So there's no sense encouraging people to try it. And it gets tried all the time. Another good example is overcrowding or density increases. The bylaw needs to say that being protected from overcrowding is a locally protected interest. Otherwise, it's not. There's nothing in the Zoning Act that would make that something that is protected. The usual interests that are zoning, they're zoning related or zoning cognizable, the court has called them, are traffic, noise, stormwater, lights, parking, litter. Those are the kinds of injuries that you need to claim an injury of that sort in order to have standing and be a proper plaintiff in any appeal. The rest of section 1 is simply citing authority. Chapter 40A is section 1.3 and article 89 of the Constitution of Massachusetts. That's the so-called Home Rule Amendment. Zoning in Massachusetts is pretty much the exact opposite of many states across the land. In most states, I would guess Dillon's rule still applies. If the Enabling Act doesn't say that you can do it, you can't do it. But in Massachusetts, Home Rule Amendment allows you to do anything, not necessarily mentioned, but anything which is inconsistent with or preempted by state or federal law. So you basically have the entire world in which to operate as long as it's not preempted. A really good example, years ago, 100 years ago now, I started protecting groundwater by helping municipalities draft overlay districts. Nowadays, that's a dime a dozen. In Massachusetts, I didn't need to go to the legislature and ask for permission to do that. I could do it because it wasn't inconsistent with or preempted by anything. In Connecticut, where I was also working at Ford Foundation money, we had to go to the legislature and they had to amend the State Zoning Enabling Act to say that protection of groundwater through overlay districts was a permissible public purpose. Without that, we couldn't have done it. So two very diametrically opposite approaches. And some of the great stuff in Massachusetts zoning annals comes out of the creativity of local municipalities taking advantage of home rule. My favorite is certainly Sturgis versus Chilmark, in which the town not only adopted a rate of development bylaw, but they also adopted a program for youth lots by which deficient lots by special permit could be used to house people under the age of 30 who had lived in town for more than 8 years, who were income eligible. And that went all the way to the Supreme Judicial Court. And it was upheld.
So, and with that, I believe we've got a question from Mr. Hogan.
Attorney Dombrowski, if we go back, Chairman Lieber, up to the previous section, I did have a question before we went past it in terms of the policy decisions that are being made here. Obviously, even if we just copy and paste, but is the promote prosperity and well-being of inhabitants while retaining rural characteristics of the town, is that a component where that is there's a understood enforceable threshold for that language? Does that open us up as a town in terms of some of the developments that we have for parties aggrieved to appeal on the basis of that language?
I don't think it goes that far. I believe that the promote the prosperity and well-being language is from section 2A of the uncodified section in the Zoning Act amendments that were passed by the legislature back in 1975. So section 2A, you don't see it in the law book. It's not published in the statute book. It was an advisory section that guided municipalities as to purposes for which zoning could be used.
I don't think prosperity and well-being is really the where I'm concerned. The concern is where you have the while retaining the rural character of the town, except I feel like significantly more controversial. I mean, everyone wants prosperity and well-being. If you don't, you're kind of weird.
I would treat these as a sushi menu, and I think if you don't like it, you take it out. If you do like it, you order it. You can see what you had before. It's a much more abbreviated list. It's in the strikeout at the bottom of the page. And I mean, to the extent that you wanted to just keep that old purpose clause, that's fine. Again, I would not put to protect and conserve the value of property in there.
And I guess maybe this is more of a comment for all the relevant parties on the phone. I'd encourage us to think about that, to Attorney Dombrowski's point, whether or not we would like to keep it or not. And the other one is the overcrowding and undue concentration of population. Again, highly controversial within town, but something we might want to think about as a series of boards as we get farther along in this process.
Mr. Noel.
Yeah, I think Ann and I were nodding to the exact same points. The rural character of the town seems pretty controversial, and I would agree with Jim. Certainly, I don't know what overcrowding and undue concentration really refers to. So, Ann.
Yeah, we don't have a rural character in this town, so that's what concerns me.
Yeah.
No matter what some people would say, as someone who's lived here for 40, 50 years. So that worries me, that description. And I don't know if rural takes on more of a legal significance, or is it just something that was thrown in there? Because if it has, these are things that folks are going to look at very closely, especially with some new development happening. So I do agree that we need to be a little careful of what's included in this sushi menu.
So noted. So my marching orders, as far as I can tell so far, is to take out the second bullet and the bullet that says to prevent overcrowding. If there are any other ones that you think are inappropriate, then just
I think the issue is really just the phrase, the second bullet. It's just the words while retaining the rural character of the town. I think if you were to strike out those words, the promote prosperity and well-being of its inhabitants, I think sounds good. Doesn't really do much from a practical perspective, but
Yeah.
it's feel good language. It's what I'm hearing is the resistance is really on the word rural and the lack of definition around what that means. Because where this town does have agricultural roots going back several hundred years, it is now very much a suburb. And it's, if we were to say suburban character of the town, not quite sure that has much more meaning one way or the other, but it sounds like it's not needed at all to have that language.
Okay.
And then to prevent overcrowding and undue concentration, I think that's highlighting that, I think, is important, because I think that's a point for discussion. And if there's any sort of reference point as to what that means, that could be helpful to understand what it's really getting to, as to what that would do for standing, because it's certainly a concern that I know many of us have heard, is a desire to prevent overcrowding. It becomes a matter of what is that threshold, because we also have a need to have enough housing for people and have enough affordable housing. So that as an MBTA community, that's certainly an issue.
Well, I think what it essentially means is that people will follow the rules set forth in the dimensional tables and other dimensional regulations. To the extent that a board grants a discretionary permit or doesn't require a permit, and it results in overcrowding, the most recent case from the Supreme Judicial Court, which is a case from Sherburne, Murchison versus Sherburne, said you've got to show not that just that there was a violation of the zoning bylaw, but also that it causes you injury sufficient for standing. So it's violation in and of itself is not reason enough to have standing. It's got to be a violation which causes you injury as a result. And injury from overcrowding means injury from traffic, injury from lights, injury from noise, injury from stormwater. It doesn't, unless your neighbor is building something an inch from the property line, it's unlikely to mean that.
Okay, if there's a way to document that, that will be, I think, very helpful in explaining, because I see that language is just being very much a lightning rod in this particular community. Mr. McGrail.
Thank you, Mr. Chair. If you could just scroll up, I just have one little correction I think that needs to be made. At the 1.2, it says the town of Irving. So that needs to be changed to Wakefield. And I think that's maybe where the rural word came from.
Yeah.
I think it originally came from Framingham. So.
Wow.
So that's my only comment, just so we don't leave that in by mistake.
I got it.
Yeah.
And I'm assuming that it's not referring to the gas station that's over on Salem Street either, of a slightly different spelling.
All right, so the remainder of the provisions, 1.3, go to the authority, legal authority to do this. The scope, 1.4, is the scope of the applicability of the zoning regulations. Applicability is something which requires the zoning to be applied even when greater restrictions are called for in the zoning bylaw than those imposed by other regulations. the bylaw will control. And then amendments is something regulated by general law, chapter 48, section 5. So a lot of the strikeout that follows after section 1.6 is a strikeout because you have simply repeated the statute, which might have been useful 20 years ago, but everybody knows to just put mass gen laws into Google and the statute pops up. And by the way, under E, there is now, as a result of the governor's housing amendments from a couple of years ago, less than a 2/3 vote possible to adopt certain zoning measures, including accessory dwelling units, MBTA communities, and multifamily and mixed use housing. So
I think that also addresses an issue that Bob Vincent, who is also in the meeting, had previously raised. So thank you for pointing that out.
yeah. And then literally the rest of the strikeouts is language that is in the statute. So you have to make a fundamental call early in the game, whether you're going to reprint the procedures of the legislature as set forth in the statute. If you do, you're going to have to constantly monitor the statute to make sure that there hasn't been a change. And periodically there is a change. I've taken to recommending to municipalities that just a simple citation to chapter 48, section 5 will suffice here. Unless you have some sort of a local rule that you want to perpetuate. For example, some towns charge petitioners for warrant articles that are private in nature. They're changing the zoning on their property. They'll charge for a map change if it needs to go through GIS in town hall. Those are the kinds of things that usually people get a bill for. So if town meeting has a map change in which somebody is proposing to change the classification of their property, it's obviously got to be a map. It's got to come to town meeting as an identifiable parcel. And then afterwards, it has to be put onto the zoning map, all of which costs somebody time and money. But you don't have that now. And then severability. Many of your sections in the bylaw have a severability clause, but you only need to say it once. So there it is. And then the effective date of a zoning bylaw is the date of adoption by the town meeting, although it does have to go to the Attorney General, and the Attorney General has 90 days after the package is received in Boston to decide whether the bylaw is defective or good. But the effective date is the date of the vote. And there's another exception to that, which is that if the bylaw is advertised when the first notice of the public hearing is put in the newspaper of general circulation, if you're in process for a special permit or a variance in particular, if you're in process and ultimately that's voted on favorably by town meeting, you are retroactively subject to that rule change, zoning change, because that's the nature of vested rights here in Massachusetts. That's a provision in chapter 48, section 6, right in the first paragraph. Sometimes causes problems because you're in no man's land between the date of the advertisement of the public hearing and the actual town meeting vote. You don't know whether you're going to be stuck with that bylaw or not, and you have to wait to see if town meeting adopts it. If they do, it's backdated to the date of the planning board public hearing notice in the newspaper. Very confusing.
Just to add to the confusion, I don't think it may not require changes to the language. Wakefield has a very unusual element in it, the charter, that actually delays the adoption of any vote on most matters for 10 days after the town meeting concludes, because we actually have the ability to have almost any item moved to a ballot from town meeting. So there is a referendum procedure that's dictated in the town in the town charter. I don't think I believe it just suspends the action for during that 10 days. I don't believe it would invalidate this or change any of the other issues that you're raising, but just so you're aware of it.
I'll take a look. That's interesting. I'd like to see it.
It's awkward. in
It's all
execution.
awkward. I mean, what the legislature's done with the three things, the effective date being the date of the town meeting vote, but if you're in process and the planning board notice appears in the newspaper of the public hearing, you're stuck with it, and then the AG giving you the delay at the end. There's three confusing things all working against you. The other thing I did in the section 1 language, and you'll see the strikeout, this is the fee requirements. Generally speaking, putting them in the bylaw is cumbersome. They don't need to be in the bylaw. They could be adopted as rules and regulations of the special permit granting authority, whether it's for a special permit or for a variance. And I rarely see, if ever, fee schedules in the zoning bylaw, simply because you have to get a 2/3 vote at town meeting to put them in and a 2/3 vote at town meeting to change them.
So before we go on, just from a process perspective, when we are ready to submit this to town meeting after we've gone through however many drafts are necessary, do you recommend that we try to work with planning board to hold those public hearings close in time to the town meeting itself, so that the amount of what you're calling no man's land is diminished?
Well, I'm talking about the no man's land created. So the statute says that Chapter 48, Section 6 says that no ordinance or bylaw shall apply to a structure in existence or a use already commenced. And then it goes on to say, that makes sense, right? Then it goes on to say, but it will apply to basically an application pending if and when the planning board notice of a public hearing for a zoning amendment appears in the newspaper while no special permit or building permit is in hand. In other words, to be protected from a pending zoning amendment, you need to have a special permit, not in process, but in hand. And the same is true of a building permit. If you don't have it in hand, but you only have it in process, you're stuck with the amendment if it passes town meeting. So many towns want to jump out early in the game. It's 6 months for a public hearing for a zoning amendment until you have to put it on the town meeting warrant, 90 days in a city, 6 months in a town. So if something is really bad in your bylaw and you want to jump on it and you want to put something in motion by having an advertisement in the newspaper, you could effectively hold up people in process for 5 or 6 months. But after that, the warrant article becomes stale and you have to do it over again.
Okay, and what I'm taking from that is that just for the lack of confusion, we'll probably want to keep the amount of time from the notice of public hearing and the public hearing by the planning board on the final changes. We'll want to keep that amount of time reasonably short.
Yeah, I mean, I've gone to town to planning board public hearings on the morning of town meeting. I specifically recall Wenham Saturday public meeting or Saturday town meeting, but we held a meeting of the planning board, a hearing of the planning board to put the final tweaks in the zoning, and then walked into the town meeting. So there's no specific time frame that is required by the statute, as long as it's not 6 months, and because at that point it's stale.
Thank you.
Okay. So I'm going to ask you, Dan, if you would put up section 5. And I understand that the Board of Appeals may have some members with you this evening.
We do. Let me share section 5.
So this is truly, I'm not joking when I call it the black hole of the Zoning Act. It's a little bit, in a former life, I was a European history graduate student, and the only thing I can think of to compare this to is the Schleswig-Holstein question. Like, is it Danish or is it German? You tell me. This has also been called difficult and infelicitous by our own appeals court in a case many years ago. So it's just riddled with problems, but it does have an organization, not necessarily reflected in your current bylaw, but it does have a basic organization. First of all, the cardinal principle here at the beginning is that non-conforming uses and structures have to be tolerated as they were on the day they became non-conforming. You can't make them be torn down. Right? You don't have to do anything more than tolerate them, but you have to tolerate them. There were, in the legislative history, there's actually some language that talked about municipalities buying non-conformities and compensating the owner for them, taking them, and then getting rid of them. But obviously we don't have the money for that, and we never did. So the first thing is that you control your own destiny. So once you get past the basic principle that you have to tolerate them, you can do more. Most towns allow for alterations and changes to non-conforming uses and non-conforming structures. And there's two ways to do that, procedurally speaking. One is a finding, and a finding is on a 5-member board is a 3-2 vote. That's the only difference between a finding and a special permit, which on a 5-member board is a 4-1 vote. So you can make that call right off the bat. Some towns use findings for the alteration of single and 2-family homes and special permits for the alteration of everybody else. All kinds of possibilities there. But you'll often hear the term finding thrown around loosely. It has a dual meaning. You make a finding when you're deciding a special permit, but the finding in that case is basically a finding of fact. On the other hand, a finding as a procedure, which is a different thing, is a 3-2 vote on a 5-member board. Interestingly, on a 3-member board, a finding would be a 2-1 vote, but a special permit would be a unanimous vote of the 3-member board. So just something to think about. The other really important thing about the statute is that it pretty much does the work for you in terms of dividing nonconformities up into their various categories. So there are 3 principal categories: nonconforming uses, and I take them in this order in section 5. The second one is nonconforming structures. And by uses and structures, I'm referring to everything but single or 2-family homes. And that's the third category, nonconforming single and 2-family homes. And it's pretty clear that the legislature had in mind that they would give a break to people with nonconforming single and 2-family homes, where they hold the feet to the fire for people that just have a nonconforming widget factory or a nonconforming structure that is not a single or a 2-family home. So the single and 2-family home tend to be treated a little bit more leniently by the statute, whereas the other 2 categories are treated the same, but a little bit harsher. When I look at your provision, for example, on the, if you skip past all my stuff, I should have struck it out, but I didn't. It has 190-49, non-conforming use or structure. Non-conforming use of a structure is defined as use of a building, lot, or structure that does not conform. Okay, but it might be the structure itself that's non-conforming. So it's possible to have a conforming use in a non-conforming structure, or a non-conforming use in a non-conforming structure, in which case you need 2 special permits to alter, not 1, because they're different categories. So if you go back to the language that I provided you with, section 5.1 basically says that we have to tolerate you. And there's that provision that talks about the general newspaper of general circulation and the publication of notice of the public hearing. That's taken right from the statute, didn't change a word. That's chapter 48, section 6, paragraph 1. This 5.1.1 is another provision that says exactly what the statute says. In fact, the statute says ordinance or bylaws shall say this. And then it picks up with construction or operations. Until about 5 years ago, it was 6 months, but to commence construction, and now it's 12 months by statute. So that's a statutory change that's been incorporated. The next big lesson here is that if you're going to allow for changes to non-conforming uses and non-conforming structures, you have to say what changes are eligible. If you don't say what changes are eligible, you kind of violate a basic rule of special permits, which is that it's for specific uses in specific districts. So when I put permissible changes, 5.2.1, I'm listing things that can be done, considered by the special permit granting authority here by way of alteration, a proposal to alter a non-conforming use. Change or substantial extension of the use comes right from the statute. That is in chapter 48, section 6. Change from one non-conforming use to another less detrimental non-conforming use is not. And it's something that you basically want to talk about because it's pretty much a local invention. And you either want to do it or you don't. So what it means is that if I have a non-conforming piece of junk and I'm not going to get a variance for it because it doesn't qualify under the variance statute, more on that later, but variances are to be issued sparingly, and every variance has to have its grounding in unusual soil conditions, shape, or topography. So if I don't have any of that stuff, I'm stuck with that awful thing on the property. Just as an example, I had a client in Norwood where I wrote the zoning many years ago, and the client owned a building. He had 6 apartments and 6 storage units right across the street from the hospital, which is downtown Norwood. And he wanted to basically modernize the building. In order to make it work economically, he basically wanted to do 12 market rate flats. That wasn't an allowed use. It was another non-conforming use. So the statute here is basically asking the question, should we let this guy knock down his non-conforming structure with its non-conforming uses in it and rebuild something by way of a new non-conforming use that's going to be a hell of a lot better than what he had there before? The building was like 1885. You couldn't rewire it. It was just, he could basically have a vacant lot or the old building. That was it. So the town gave him what he needed, which was special permits, and the building is built today. You can go see it. It looks a whole lot better than what was there before. So this takes some judicial temperament, if you will, in order not to let people get away with murder, because they are effectively, I'll just say it, if it's effectively a use variance without the hardship test. Think about it. I want to swap out something that's terrible, really terrible, and I want to put something that's clearly better, but the thing that's clearly better is not allowed. So it's a use variance without the hardship test. And I've seen this work really well. Cities like this a lot because they're stuck with the variance statute, which is very unfair in my opinion. We overreacted in 1976 when we rewrote the variance provision. Prior to 1976, a variance was for peculiar circumstances on a lot. Now it's very strict: soil conditions, shape, topographical features. If you don't have one of those 3 things, you don't qualify. So it's pretty useless, because my experience tells me that about 80 to 90% of variance applicants are never going to get there from here. It just doesn't work. So, you know, in a large city or a large suburb, flexibility is sometimes something that you find in weird places. Here's one. So if you want to be able to do that, you very clearly have to list it. The case is actually interesting. It's called Blasco versus Winchendon. Blasco Blasting Company wanted to convert a non-conforming gravel pit, a hole, into a non-conforming demolition landfill, a filled hole. Well, that's a good idea. The neighbors, however, said it doesn't say you can do that in the bylaw. They sued worrying about the leachate, and they won. So the courts, the principle from the case is, if you want to be able to do it, you have to list it. That's why it's here. It's an option. When you get to non-conforming structures, 5.3, you can see the permissible changes on the next page. And both of these are listed in the statute. Reconstruction, extension, or structural change. And then the second one is altered to provide for a substantially different purpose or for the same purpose in a substantially different manner or to a substantially greater extent. That's in the statute, and I don't see that anywhere in your existing bylaw. But that's not something that you should have just walked away from, because the statute says this is something that I can apply for. And I think it's a very rare situation. I think there's only 2 reported cases since 1976 on the second option. One's from Cambridge, but it's a useful thing. For example, in Concord, we had like many towns, we don't like banks and real estate offices downtown. It just takes up a lot of the room, and it doesn't really encourage economic growth. A bank wanted to take over what used to be an art gallery, all in a non-conforming structure. They didn't think they needed a special permit until somebody, namely me, pointed out altered for a substantially different purpose requires a special permit. And it's a men's clothing store today, not a bank, which was a good ending for Concord. The variance required is a codification of the holding in a case called Rockwood versus Snow Incorp. In that case, a non-conforming building was being altered in such a way that no new nonconformity was being created. It wasn't a house, it was an office building or Snow Inn. And the court said that even when that happens in the case of a prior lawful nonconforming structure, even if no new nonconformity is created, it still needs a special permit. And if a new nonconformity is created, it needs a variance. So that's essentially the holding in 5.5. It's just it only applies to nonconforming structures, and it only holds that specific thing. The most fun you can have here is 5.5 for single and 2-family residential structures. So your bylaw right now has a section under 190-50, pre-existing may be reconstructed, changed, altered without the necessity of a public hearing, provided it's determined that no reconstruction change shall increase the non-conforming nature of said structure. That language comes out of the statute, and it's very mysterious, isn't it? What's the non-conforming nature of a structure, a house? How do you figure that out? So we've got a lot of history over the dam at this point. Years ago in an Edgartown case, the question was put to the Supreme Judicial Court. What does this mean? One of the justices had a house in Edgartown, so she recused herself. 3-3 vote. One faction of the court said, look at why the structure is today non-conforming. And if that specific thing didn't change, the non-conforming nature didn't change. And the other side said, no, let's squint at the building, and if it looks like it's going to get bigger, let's say that the non-conforming nature is going to change. That was a tie vote. Ultimately, what happened in a subsequent case called Bjorklund versus Norwell is that the court decided that the squint test was the best test. So what today we have as a result is a system by which everyone has to apply for a special permit. And the special permit has 2 steps. One, does the proposal increase the non-conforming nature of the single or 2-family home? If it does not increase it, the case law says that the applicant is entitled to the issuance of a special permit. And that's not really very good law under Section 6, because no one's entitled to a special permit. So what my bylaw does is deem these 3 indented paragraphs not to increase the non-conforming nature of the structure. In other words, help the building inspector out. Let him know objectively what is not going to increase the non-conforming nature of the structure. So look at the first one, insufficient area. If the structure has a lot with insufficient area, it's not the lot that's non-conforming. That makes the structure non-conforming. But if they're proposing to alter the structure in such a way that the alteration, front, rear, side, and height complies with the zoning bylaw, bingo. It didn't increase the non-conforming nature of the structure. If the lot has deficient frontage, it's not the lot that's deficient, it's the structure. So if the same test applies, if the structure, front, rear, side, and height meets the alteration, meets the zoning, bingo. No public hearing, give them a building permit, essentially is what this is saying. And if the last one on encroachment applies, so the lot's in a side yard because it's shoved over to one side of the lot, but the proposed alterations in the other side yard and it complies, excuse me, front, rear, side, and height, give them a building permit. This gets people home earlier. It also doesn't engage the neighborhood in a fight they probably shouldn't be having, because these three examples are pretty clear in most cases that the non-conforming nature of the structure was not increased. The structure might have been increased in size, but not the non-conforming nature of the structure. And then if the building inspector determines that neither subsection 1, 2, or 3 applies, it goes to the board for a special permit. The other thing that's buried in the first paragraph under 5.5 is an arbitrary rule that I've put in there that every time a non-conforming single or two-family home is increased in GFA, gross floor area, by more than 100%, it should go to the board for a hearing. And that's basically putting a roof on a ranch, a second floor with a roof on a ranch. In the Bjorklund case from Norwell, I believe the house was quintupled in size, and it would, and unless you put something in there like 100% or whatever number you like, it's not going to get a public hearing if it meets 1, 2, and 3. So, this is this stuff that I've been toying with here and perfecting is in 75 towns at this point in time. And it's not like I'm getting calls from people that say, our world is ending. I don't hear anything, generally speaking, about the treatment of nonconformities in these three categories. There's a couple of special cases on the next page in 5.7.
Real quick before we go on with
Sure.
that, one of the issues I have seen come up is the conversion from single family to two family, and would this basically state that would be permitted as long as one of those, if the structure itself wasn't actually being changed in size, so or being changed in the area frontage or encroachment. So if one of those applied, that would be permissible.
Well, it wouldn't make anything permissible that's not permissible already. So if your zoning says that in the R1 district or whatever district that you can have either a single or a two unit house, then you could ask for permission to have 2 units. But it wouldn't change if a 2-unit dwelling was not permissible in that district. It wouldn't create any rights to have a 2-unit dwelling.
Okay, so it would be dependent upon the district itself.
Yeah,
but it would allow for the conversion.
If your bylaw already does.
Right. So where 2 families are permitted, then it would allow by right a structure where the structure itself isn't changing. It would allow for that change is what I'm reading. I'm not saying that's
because I wouldn't reach that conclusion here, because if the bylaw says I can have 2 units in a dwelling, then I don't have anything non-conforming to work with there. I mean, I'm seeking to make my 1 unit into a conforming 2 unit, but the bylaw has to give me a clear path. Nothing happening here in section 5 is going to do that. I think I actually had a case in Wakefield 15, 18, 20 years ago where a woman had a huge house and she wanted to convert it into a 2-unit. And I remember, I don't think we were asking for a variance. I think we were asking for a special permit.
Mr. Hogan.
And I might have to defer to members of the ZBA who are on this, but this non-conforming single and 2-unit structures, we currently approach this via a finding, correct? In lieu of a special permit for these non-conformings. Is this a change to what we're doing right now in terms of the 4-to-1 versus 3-to-2 threshold?
I'm just pointing out that there is that choice. And if you're doing findings now and you're happy with them, then I would assume you would want to continue that. But the only difference between a finding and a special permit is the quantum required for approval. And, depending on the size of the board, 3, 5, and 7-member boards for a finding would be 2-to-1, 3-to-2, and 4-to-3. Whereas a special permit is 3-to-0, 4-to-1, or 5-to-2. And as I said, you could do findings for single and 2-family homes, and then you could do special permits for widget factories. The possibilities are there. Let me just get you through the end of this. If the statute was rewritten in 1976, it used to just say abandoned, but there's been very few cases in which abandonment has been found. Abandonment is generally a subjective inquiry into the mind of the owner of the property. Hey, Joe, did you mean to abandon the house? No, I'm coming back. Well, he didn't abandon it. On the other hand, hey, Joe, did you not use the house for 2 years? That's more objective. And that's why the legislature changed that in 1976. We can get into, angels on the head of a pin as to what constitutes use versus non-use, but you kind of know it when you see it. I had a case many years ago where the guy up in Salisbury Beach wanted to buy a tavern and convert it into a food court right across the street from the beach. The owner of the tavern died during negotiations. And as 2 years was coming around, he took out a temporary food license, but I didn't know him at the time. Had I known him at the time, my family would have gone up there with balloons and crepe, and we would have made the whole thing look like a grand opening. But he kind of camped out in the building for 3 hours for 10 days. And he tried to argue that he had used it again and went all the way to the high court. And they said, sorry. So what I've also added to the section 5.6 is that if it dies, if it's not used for 2 years, then you can bring it back to life by seeking and getting a special permit from the Board of Appeals. So the Board of Appeals can say, well, we so value this as a non-conforming use that even though it had a 2-year lapse, we're going to let you bring it back. A good example of that is the Sterling Inn in the town of Sterling. Was an old community treasure, and it had a kitchen fire, and it was out of service for 8 or 10 years. But somebody made a case that they had marketed it that whole time as a restaurant, and at least one person got to make a try at bringing it back. I don't think it survived. Under reconstruction after catastrophe or voluntary demolition, you've got reconstruction after fire. But what if I just want to tear down my house and rebuild it? There are cases that say tearing down my house is, you couldn't have a clearer statement of abandonment, right? You tore your house down. So you have to be careful how you do it, because you don't want to lose everything. And this sets just basic rules for voluntary demolition. I think Wakefield probably has seen tear downs to some extent. Concord is, we're tear down headquarters over here. And then small capes come back as mid-size colonials. The rule basically that I've put is if you rebuild it on the same footprint with the same GFA, then God bless you, good luck, here's a building permit. But if you're going to move the footprint or make it bigger, you need a special permit. So every rebuilt house has its own hearing, and the neighbors get to come and talk about whether it's McMansionization. And then the last three provisions are a lot simpler. Reversion to nonconformity is not possible. Substandard lots. When I was on my planning board, people came in all the time with an A&R plan. I want to trade this triangle of land to my neighbor for their triangle of land. And is your house nonconforming? Yes, it is, but it's the same triangle in area. Well, the rule of nonconformities is that you're protected to the extent you didn't change anything after you became nonconforming. If you start changing your lot, you lose the protection as a nonconforming use or structure. So this is a circumstance that allows people to make this kind of a mistake, no harm, no foul. And then the last one is eminent domain. If the town takes property for eminent domain purposes, and it's short now, it's not going to be violative, it's going to be a nonconformity. Violative structures are, just sort of in no man's land, although the legislature did about 10 years ago write a new paragraph that said if you're violative for 10 years and nobody complained, we're going to graduate you to non-conforming. So even that is a little bit better now.
Mr. Joe, did you have a comment earlier?
Yes, Mr. Chair, I did. If you scroll up, some of the wording didn't make sense because under the single and two family.
Which section?
Yeah, right there. Does that mean that they don't have to come to the ZBA if does that mean that it can be determined by the building inspector?
Yeah, yes. As long as the house is not being more than doubled in size, that's the 100% rule.
All right, I might have
And
missed that.
and if 1, 2, or 3 applies, I mean, it could be 1 and 2, for example, if the lot is both deficient with regard to area and frontage, but the alterations in complete compliance with the zoning bylaw, both of them would allow you to get this on a building permit.
Okay, so they bypass us, then that the building inspector can make that determination himself.
Yeah, but see, that's what the appeals court said in the cases where they said it's a 2-part test. Come to us and we'll decide whether you've increased the non-conforming nature of the structure at the ZBA. And if we decide that you did not, you're entitled to the issuance of a special permit. And I wrote in my book back then, well, that doesn't make any sense because there's no such thing as entitlement. An entitled special permit is a building permit. So just call a spade a spade.
So why does it end there? Can't someone say, well, why can't the building inspector make the determination that what I'm doing is not more detrimental to the neighborhood? Does that mean that does it go from?
Oh, well, the next step, I think, is if it does increase the non-conforming nature of the structure, the ZBA may, by finding or special permit, let them do it anyway. I mean, there are plenty of circumstances in which the non-conforming nature of the house changes or increases, but still not a bad idea, or it's not necessarily a bad idea. So you go on to the next level of inquiry at that point.
I see. All right, thank you.
Yeah. There's a lot to swallow. I mean, this is a rewrite of Section 5. But when I look at your existing language, you've got, for example, in 190-50B, you don't have the test that says that a non-conforming structure with a changed use requires a special permit or a finding. It's nowhere mentioned there. I don't think the idea that abandoned or discontinued uses getting a new lease on life is necessarily a bad one. Obviously, it depends on the circumstances, but I think I wrote that for the first time when I was doing Holyoke. If you can't do that in Holyoke, there's no Holyoke. The buildings were all not used for decades in some cases, and they are all, now they're all live work that they brought back to life. And the restoration after fire, let's have a rule for restoration after voluntary demo. It's good for the housing stock.
Mr. McRail,
Well,
you just muted yourself.
I meant to lower my hand. Thank you.
Okay.
There we go. Thank you. Appreciate it. I've got a bunch of comments and thoughts on this. This is, as Mark had said, I think this is the most critical section of our zoning bylaw. This is a section of the bylaw that the zoning board of appeals hears cases on every meeting that they have. I think as Jim Hogan had said at one point, this is extremely applicable to single and two family houses. So it really affects the homeowners on how this operates and how it works. So I think, and I appreciate what Mark's doing, trying to organize this, because it does help. But it needs a lot of work and thought. It needs thought by everybody involved with this, because the implications are pretty significant. And I'd like to just point out some things. And I have a couple of questions for Mark, if I may, Mr. Chair.
Go ahead.
The first thing is, and Mark has said it, one thing that has to be decided is this going to be a finding or a special permit? Our town has historically been a finding town. And that has, we're not talking about a recodification here. This is a significant change and impact to people that go to the board with their houses and only need a 3-2 vote versus needing a super majority vote. And what happens with special permits, don't forget, is boards can put conditions on special permits where it's not as easy to do so with a finding if it's not specifically related. So that's just one thing for everybody to consider. And then I guess I had a question on 5.1.1, Mark. You pointed out the commencement of within 12 months of the building permit.
Yes.
Permit.
Right.
And I got to tell you, I never noticed that was statutorily required to be in a bylaw, as you pointed out. I've never seen it in a bylaw.
Yeah.
The question is do you deem it necessary? Because I always hesitate to almost quote sections of state law in a bylaw, because it creates a problem if the legislature changes it. And as you would mention, this used to be 6 months, and now it got changed to 12. And
Right.
now you have conflicting terms in your bylaw versus state law. So I do respect the fact that it says it needs to be in there. I've never seen it in another bylaw. Would you be overly concerned if we didn't include it?
Well, I'm just going on Google here to just pull up Mass General Laws. Hang
Oh,
on
it
a
says
second.
shall. I looked at it.
Oh, it does say that ordinance or bylaws shall.
No, your point's well
Yeah,
taken, but
Yeah, no, there's only one other provision in the entire statute that says that. It's the lapse provision under Chapter 48, Section 9. So what this is saying is that even if you beat remember what I said before about a special permit or a building permit needing to be in hand prior to the first appearance of the ad for the planning board public hearing in the newspaper. Even if you have it in hand, they're still coming for you, because this paragraph says the construction or operations under a building permit or special permit shall conform to any subsequent amendments unless you commence use within 12 months.
I have no problem with it. I understand that's the law. My only suggestion might be where we reference 12 months, we might put something in there that something to the effect that amount of time would change as the state law changes automatically, because my concern would be that the state law, for example, changes it to 24 months and now our bylaw is 12 months. So, people are looking at the state law and this is buried in our bylaw and they could get tripped up. So there could be some tie-in language on that possibly to just make it kind of mirror the statute if the statute changes the time period.
Well, yeah, and it just did. So I'll find some generic language that talks about,
Just a thought on that.
as may be applicable or something. So I
And
get
then
it.
if you can indulge me, because I do have a number of comments because I work with this bylaw every day on 5.2 non-conforming uses. It says the zoning board of appeals may grant a special permit, and perhaps that will change the finding as we go, who knows? But it says to change a non-conforming use. I think that needs to say to change or substantially extend, because those are the two standards that can be done by special permit. It's not just a change. You can have a substantial extension also.
Yeah, well, and so number one in permissible changes is change or substantial extension.
Yeah, but I just for consistency purposes, I just don't like, just to use that word change. And then down below, we have change or substantial extension. I think it's just wordsmithing.
Yeah, okay, I don't have a problem with that.
Just a point. And then
second-
where it says 5.2.1 permissible changes, and I think it should say in the heading, permissible changes and substantial extensions. And then I think the ability to go from one use to another is excellent. You know, a lot of towns are going that way. It gives flexibility to the boards. So
Yep.
I think that's a great idea. I was just confused, Mark. I understand where it says no use variance shall be required because
Yeah.
you're doing that. But it says with regard to use or dimensional aspects of the application. How does the dimensional aspect come in if it's a change in use? Is that appropriate there, or, you know, maybe I'm just missing something?
So I put it in because even though I wrote the zoning in Norwood and years later came back to take advantage of this, a member of the board, over the opposition of his other 4 colleagues, and the opposition of the author, me, said you need a variance. And the thing he hooked on was that there was a formula for new construction of market rate housing, and the formula would have yielded 6 units. And that wasn't a use, that was a dimensional formula. So in order to clarify that, I thought that putting something like no use variance or with regard to use or dimensional aspects of the application, just to make it abundantly clear that the formula didn't apply unless it was for new construction.
Thank you.
I don't know that it worked, but you know, you learn as you go, and he's the only person who ever made the argument that a variance was still required.
Great. And then under 5.3, it says the zoning board of appeals may grant a special permit to reconstruct, extend, alter, or change. I'm wondering if reconstruct should be taken out of there because that's specifically dealt with in 5.7.
Yes. And the term reconstruct was construed in a case from Nantucket to mean demo of a building, raising the building and reconstructing it thereafter. So it's not, there was a line of cases that used a test as to whether or not the building had at least one wall left standing, and then rebuilding it was reconstruction. But it didn't include knocking it all down and reconstructing it.
I just think it's maybe redundant because it's stated there, and then 5.7 specifically deals with reconstruction after voluntary demolition, but it's the same standard anyways in both. So, and then moving on to 5.3.1, permissible changes. Following types of changes to non-conforming structures may be considered by the zoning board of appeals. 1, reconstructed, extended. I think what I would suggest is if you everything says reconstruct, extend, alter, or change, and sometimes like certain words are left out. So there, for example, it says reconstructed, extended, or structurally changed. I think the word altered should be inserted there too, just for consistency.
Okay.
And then if you look at 2 is altered to provide for a substantially different purpose. And I think those same words should be used again.
I think those words come right out of the statute.
I'm sorry.
I think number 2 comes verbatim from the statute.
I just get confused by that because, you know, now you're in a debate before the board. Is this an extension or an alteration? If it's an alteration, you can do it. If it's an extension, it's not allowed.
Mm-hmm.
So just something to consider and talk about.
Okay.
Okay. Same thing with variance required. Again, it says except as provided in 5.5, the reconstruction, extension, and I think alteration should be inserted there.
Mm-hmm.
And then the last sentence of this, the extension of an exterior wall added along the same non-conforming distance with a required yard shall require the issuance of a variance.
There's no case on point, so that's a sushi menu option. It could be a special permit.
Do we need anything? I mean, basically, isn't that something that, you know, it's not, you know, the board could determine that it's not an intensification of that nonconformity because you're not going closer to that line?
Well, since in most cases, the alteration of a non-conforming structure other than a house or a 2-unit house will require a special permit. So there are very few cases that I can think of in which a widget factory can be altered, even if the alteration complies in all respects without a special permit or.
Even
or-
extending down the same, even if you're not going closer on that line.
Yes, yeah, that's what the statute says.
Okay. So you're saying it potentially could be a special permit though?
Yeah, and so the question becomes if I'm, if the existing structure is 8 feet from the sideline and the district requires 10, and I'm extending that wall, but keeping it all 8 feet from the sideline, half the world is going to say, well, it wasn't there before, so it's a new nonconformity. And the other half is going to say, but it's no closer, so it's all good. So there's no case that says that's a variance or a special permit.
Yeah,
And
that's what I thought.
yeah.
Okay. And then, these are just ministerial things, but things, Dan, for you to maybe take note of. And on 5.5, non-conforming single and 2-unit residential structures, our bylaw refers to them as single and 2 family. But
a
not,
lot of people do, and a lot of people are getting away from that now.
yeah. I mean, I'm just saying how our bylaw historically has it. So.
Well, I've worked on a couple of bylaws recently where all of that was excised from the bylaw, and it went to more generic language like household, or it's all, it's part of the culture now.
So going on, so in that paragraph, non-conforming single or 2-family or 2-unit residential structures may be extended, altered, or structurally changed upon the termination of the inspector of buildings that such proposed, and now we have the word reconstruction that comes in here.
Yeah.
And I don't think that should be there, because if you go to the bottom of 5.51, it says, in the case of the voluntary demolition of a single or 2-unit structure, reconstruction thereafter shall be governed by 5.7.
Yeah.
So I just think that's my suggestion, that reconstruction would need to come out there.
All right, so I'm going to ask you to do something for me, Brian.
Yep.
Can you just take this? I can send it to you in Word.
Yeah, I'd be happy to, Mark. Yeah, and
just track it and send it back to me.
Yeah, I'd be happy to. And then, the same thing with the permissible changes. I'm thinking that alteration should also have structural change or extension. Because I know this has become an issue in other towns that I practice in, that the term, well, wait a minute, you can, those 3 standards are okay for an alteration, but it doesn't say an extension. So if you put an addition on, that's an extension, so you really can't do it. So just for us to be clear, if we're going to go this route, to have consistent language throughout it. And then the thing that is being proposed on the bringing an abandoned use back to life is an excellent provision and an excellent thought. I mean, that's because I think, I've seen it in my practice, that can be catastrophic for people. And if a town supports like a non-conforming use that makes some mistakes or goes, has a problem, goes out of business, and they want to come back, the whole town wants it to come back, and Mark has given us a mechanism for that to happen, where otherwise you'd be just out of luck. On the reconstruction after catastrophe or voluntary demolition, I would suggest that we should consider separating these. I think currently our bylaw, I mean, it does say restoration after fire, but it has historically been interpreted to mean, for a catastrophe. And to put standards on like reconstruction after fire, and I represented, I think a lot of the First Baptist Church with a catastrophic fire. In my practice, I've had 5 fires in the past 5 years with clients. So it's real, they happen. And the way this is now, or being presented now, you really would have to build on the same footprint. You can't exceed the same gross floor area. Otherwise, you'd need a special permit.
Right.
And, in today's world, if you have a catastrophic fire, you're probably not going to build on the same footprint. The First Baptist Church didn't, because they had to relocate it, and they had to, then they built a smaller church. And the way our current bylaw has a standard for the building inspector to determine that it can be restored or rebuilt as long as it's not substantially more non-conforming in the former structure. And like in the church, for example, it was smaller. So it was pretty
Yep, I see it.
obvious that it
Yep.
wasn't, so I just think, that's my suggestion, that those two should be separated. I've seen them, and Mark, I think that's a really important bylaw, because restoration after fire, there's nothing statutorily that allows for that. It's all local bylaw. So, and a lot of lawyers find that out and they can't believe it. They search in the statute for if a client's property has a catastrophe, in the state law doesn't protect it. So provision in the local bylaw is critical for that.
Okay.
So just a thought, that's just my thought on that.
Yeah, I see the language on the next page,
And
190-53.
And then Mark, on the reconstruction, you had a provision that the special permit shall be obtained prior to the voluntary demolition. So I know there's a land court case that basically says that doesn't have to happen, that I was able to find, and a case I had in another town that saved some people that inadvertently took something down. So I just hesitate to have that language in there, because if somebody makes a mistake and takes something down, I mean, they virtually could lose everything with that sentence in there. They would in essence have no argument. So that's just a thought on that. The provision on substandard lots is excellent, because that's always a problem when people, as Mark said, when people want to change a little lot line with a neighbor, and they don't, Mark, nobody knows what to do with that. I mean, it's like in our legal community, it's just like everyone struggles with that issue. So to have the clear language in the bylaw that you're suggesting is very helpful.
You know what it reminds me of? If I own a piece of property myself and I get married and I want my property now to be held in joint tenancy or tenancy by the entirety with my spouse, under the standard rules of construction, I have to convey my property to a straw and then have the straw convey it to the two of us. If I just add my wife to the deed, we're tenants in common.
Mhm.
And that mistake has been made so many times by so many people that they just fixed it by putting something in like we're trying to do here.
And then my last comment, I've taken enough time, is on the eminent domain. I think maybe
Mhm.
just some things need to be added in there, like lot width and some other dimensional requirements. We have lot shape requirements in Wakefield and are buried in our bylaw, and uplands requirements, and so perhaps eminent domain could take one out of those. So I think we just need to add things. And then I'm going to ask you, Mark, I don't know if you've ever seen it, because this is always a thing that I've struggled with. Have you ever seen in the bylaw that not only you're protected by eminent domain, but also adverse possession? Because that's always a struggle. And adverse possession, everyone, is if, somebody is, for lack of a better way of saying it, squatted on your land, and all of a sudden they say, hey, I own this strip of land, which is 10 feet by 100 feet. So now your 12,000 square foot lot that complies with zoning becomes deficient because your neighbor goes to court and they take your land.
Yeah, I've never seen that in a bylaw.
I haven't either. Do you think it would be problematic with it, or? You want to think about it?
I don't think there's a case, let's put it that way. There was just a really interesting case under the anti-SLAPP statute where somebody tried to prevent a house from being constructed on a vacant lot, and they brought an adverse possession claim for 90 square feet, which would have stopped the conformance of the new house proposal. And they won the case, but they only won 9 square feet. And the vacant lot owner sued them for abuse of process. And the court sided with the successful adverse possession claimant. Awful, awful result.
Well, my last point is, and this is just to consider, so on the reconstruction, on the 5.7.1, it says that reconstruction has to commence within 3 years.
Yeah.
So that would be also with the voluntary demolition. So if it's a special permit, as you know, the statute allows a community to allow it to be exercised within 1 to 3 years, for lapse purposes.
Right.
Wakefield has 1 year.
Yeah, I think I've got that changed when we get to the next.
I hope you
section.
do, because that's, yeah,
Yeah.
thank you, because that's just
Yeah.
like the worst in the Commonwealth. And so you're proposing to change that to 3, Mark?
Let me just be sure.
But whatever it is, I think it should probably, this should be consistent with that, because otherwise we'd have.
Yeah. Um. 36 months, yeah.
Yeah, great, because right now it 1 year is antiquated from what most
Yeah,
cities
yeah.
and towns are doing. That's why the legislature allowed it to go up to 3. So,
Yeah,
as Mr. Pride knows, we're back having determinations of basically good cause for not exercise, because 1 year comes pretty quick.
Yeah.
Yeah. So thank you, Mr. Chair. I've taken enough time, and I'm happy to, if I get a Word document to help with this, I'm happy to spend some time with it with Mark.
okay.
I'll send it off to you.
Thank you. Thanks for the time.
Thank you. Okay, with that, Mr. Knoll. You're on mute.
This question is for Brian. I got a little lost about the edits to 5.7. Is it you wanted a separate section for reconstruction after fire, or separating catastrophe from voluntary demolition?
Yeah, I wanted reconstruction after catastrophe, and then voluntary demolition, Theo, to be 2 separate items.
Okay.
And I wanted there to be more broad ability to reconstruct after a catastrophe versus having to get, special permits and meet certain meeting. I think it should just be what it is now. The building inspector makes a determination if it's not substantially more detrimental. And sometimes, having had fires, the building inspector will
Got
say,
it. No.
I can't make it. And so
Yeah.
he refers it to the Board of Appeals to make that determination if it's not.
Yeah. No, I just, it was more, I just wanted to make sure I understood what specifically it was changing. Thank you.
Mr. Hogan.
Thank you, Mr. Chair, and think a lot of these points are great. Attorney Bombrowski, I know that you mentioned a couple times that there are a number of items in here that are, a sushi menu in nature. Specifically, I think that the 2 biggest that seem to be impactful as it relates to these bylaws, in my opinion, listening to this discussion, would be whether or not we continue to remain a finding town or we convert to a special permit town for some of these elements, especially around 1 or 2 family stories. Additionally, the decision that we need to make as it relates to whether it's a variance or a special permit as it relates to the extension of an exterior wall along an existing nonconformity.
Yep.
So I think this is a question more directed to Mr. Chairman Lieber. How do you envision, there's kind of a two roads, right, that we need to make, and we need to give Attorney Bombrowski direction as a town. How do you envision us having that consensus emerge between some of these different elements? Because I think that there's real choices that need to be made as it relates to these different topics.
Great question. And it starts with this meeting and subsequent meetings, having the involvement of those people who have more experience and substantial experience in these matters, which includes the members of the ZBA, members of the planning board, in addition to bylaw review, attend meetings and get feedback from others becomes very helpful, so that we can get consensus within these meetings themselves. And as the document comes together, there will be additional feedback. I'm quite confident that will come from others. We're looking at individual sections right now, which in some ways is a bit disconnected and a bit discombobulated. I see that it's a continuous process. So I don't think we have to have the answers yet, because if we try to get the answers beforehand, we'll box ourselves in without understanding what the issues all are as this continues to develop. So question, I think, is spot on. And that seems to be consistent with what Mr. Bobrowski opened with. I think I've got that pretty consistent. Is that correct? Attorney Bobrowski?
Yeah, it is.
I guess my question would be, if we're looking at these two, for example, right? I don't know, Chairman Lieber, are you keeping a list of the elements that need to be decided such that there's some sort of meeting where you say, okay, in section 5.4, we as a group need to make a decision between variance, special permit. Have at it. Good luck. Or, let's have that facilitate that conversation. Or is the intent, for example, I can give you my opinion right now on those two items, but I don't know if that's the appropriate time or whatnot to facilitate that conversation.
It's always appropriate to get your opinion at a public meeting. So we absolutely are interested in your opinion for at this meeting and at subsequent meetings. As the language continues to come together, to have the opinion and to express it multiple times will be helpful, because the direction can change through this process, and I suspect in some areas it will.
So for that case, just for sake of posterity, I would strongly advocate that we continue to remain a finding town. It seems to me as if that's been a successful model for our town, and as specifically as it relates to the variance for section 5.4 for the extension, I'd advocate to keep the discretion within the town and not impose all the additional constraints for the variance process that Attorney Dombrowski mentioned. So I'd advocate that it's a special permit such that the Zoning Board of Appeals can use their expertise and judgment whether or not that particular element needs to be or can be granted, and not rely on the requirement of soil conditions and those other specifically more restrictive measures.
Thank you, and noted. So one thing I do want to mention, Mr. Bobrowski, as we're going through this, in 5.7.1 subsection 3, the last sentence, and this is something that Mr. McGrail was picking up on, the such special permit shall be obtained prior to voluntary demolition.
Yeah.
We separately have a historic demolition delay bylaw, and that's something that may be worth cross-referencing, because in that case, we actually do have language that by right actually allows for reconstruction if there is an inadvertent demolition, but only to the same condition that it was before. So there's some pieces here that allow for demolition, but also we may want to put a cross-reference to the historic demolition delay bylaw as well, because if someone does a demolition of a historic property, they basically will lose a lot of their rights for getting a special permit and so forth for about 2 years.
Okay.
Because they become ineligible. That bylaw was updated a couple of years ago.
All right, I'll look at the demo delay bylaw.
Otherwise, fantastic feedback from everyone who's given feedback on this. Anyone else have feedback on this section?
I really agree with Brian that, this 75% of the people in town never are going to need the bylaw except to modify their non-conforming home. So this is really the most important provision as far as the average homeowner is concerned.
And personally, I will second that as someone who lives in a non-conforming, very old house that predates the country. There's lots of non-conformities in here, and yes, this makes a lot of changes much clearer as to where special permits and or findings would be needed versus where they're not by right.
Dan, I agree with you. I live on an acre of land and my house is non-conforming, believe it or not.
Can we go to section 10, Dan?
We can. There you go.
Okay, so a lot of this is fine. Much more complete than I'm used to seeing. And if it's black, remember it's yours. So I don't think you need an intent and purpose clause, but there's no harm in it. I just don't normally see that with section 10. I changed a couple of things You can see the yellow highlights along the way. Compliance required. Obviously, the whole job of building commissioner has two sides to the coin. One is enforcement and implementation of zoning, and the other one is that he's your code officer too. So you can issue cease and desist orders for zoning violations as well as code violations. And sometimes it's one and the same thing. Sometimes the code is the more important remedy. The 10.3.2, you had $100 for each offense. The statute was amended many years ago to $300 for each offense. And then with regard to non-criminal disposition, I just don't understand where the provisions are. If the building inspector elects to proceed under 21D, all the terms and provisions of such chapter shall thereafter govern said action. Most towns, in violation of the thing I said before about fees, do list the amounts of the non-criminal disposition is basically a ticket that the building inspector issues. So many towns have, just hypothetically, $100 for the first offense, $200 for the second offense, $300 for the third offense. And that might be the one exception to not listing money amounts. The penalty in 10.3.2 is achievable only if a judge in district court, after a trial in front of a jury of 6, orders the fine. You can't fine anybody, although towns do it all the time. It's sometimes amusing. You don't have any power to fine anybody. You have to take them to a show cause hearing in front of a district court judge to get the fine. But that fine is $300 a day, each day being a separate violation. Some things here that just came out, for example, your 53G rules they're great. That's what 53G is all about. You don't have, however, the appeal provisions of 53G. I would leave this to rules and regulations of the special permit granting authority or the variance. I'm sorry, the zoning board of appeals or the planning board. 53G has some more provisions in it that need to be repeated. I found in terms of the zoning board of appeals provisions, I don't know whether you allow use variances or not, and I read it 4 times now. But the statute says that the Board of Appeals may only grant a use variance if the bylaw specifically says that they may do so. So that's 10.4.3. Do you routinely grant or consider use variances? So again, this is part of the statutory reform from 1976. In 1976, the Department of Community Affairs, they relied on a study that was done of Cambridge zoning practices, and what they found, I believe it was something like 52 of 56 cases, the Cambridge ZBA granted the variance under the old peculiar circumstances test, which is still the test in Boston today, by the way. And they overreacted, as I said, with soil conditions, shape, topography. And since 1976, there has not been a single reported case in which a use variance has been upheld by an appellate court. So that kind of tells you that it's broke, because if you can't get a use variance because the test is too stringent, it's a useless remedy. But in order to even consider a use variance, your bylaw has to say may grant a use variance, or it's prohibited. If it says nothing, and maybe I'm just missing it, but I don't see anything in here that addresses the question. So that's a big choice that you have to make. I mean, in many towns, I remember Natick many years ago, you know, the lawyers kind of banded together. And when we talked about taking use variances away, they really, you know, a lot of them were making their livelihood on use variances. And in a city, this isn't as big a deal. They do it all the time. It's the same statute, but they're just not as gun shy about it. In a town, you know, many towns, you would never even apply for a use variance because you have zero chance of getting a use variance. But I was in Everett. My partner is their land use lawyer. He does the casino stuff, and he couldn't make a meeting, so he sent me. And they had 4 use variances on the agenda that night, and they granted them all. So that's a sushi menu option in the middle of page, in the middle of 10.4.3.
So for those who are on the ZBA, is this something that has come up as to whether use variances themselves as opposed to findings?
Dan, I don't know, Brian, help me out, because I don't think so. But I've only been on 3 years.
So every variance that comes before you is a dimensional variance request?
Well, special permits, I'm not 100% sure.
Yeah, I mean, there's one case from, I think it was Rockport years and years and years ago, where there was a non-conforming inn on the rocks of Rockport overlooking the ocean, and it went out of business and somebody bought it. And they wanted to convert it into it was a house, and they wanted to convert it into an inn. And the inn wasn't allowed. And they made an argument that they were entitled to a use variance for that because the septic system was gigantic and the premium costs of putting pins to hold the house onto the rock in the next no-name storm were prohibitively expensive. And the court, it went through the trial court, but the appeals court said, well, if you look left and you look right, those houses are just as big as yours and they're all pinned to the rocks. So there's no hardship. That's as close as it's come. But you just have to make a call. It has to say may or may not. So it's, it's the same level of complexity as finding or special permit, really.
You're saying that this has only been utilized successfully twice in the last 50 years?
I'm saying that it's never been used successfully. No one has ever gotten a use variance since the statute was rewritten in 1976 that has been upheld by an appellate court. And that's because a use variance, I don't need a house there, I need a grocery store. And the reason I need a grocery store is because of soil conditions, shape, or topography. I don't think you can get there from here. So that's why there's never been a successful use variance. But they get granted all the time. It's just that they're not appealed. I mean, my night in Everett, I had 4 use variances.
So to try and distill that, it's the decision is really a practical one as to whether the town should allow the granting of the use variance, knowing that if challenged, it is unlikely to be upheld.
Very unlikely. And that discourages a lot of boards, from considering use variances, but they're of enormous usefulness, benefit, in the right circumstances. It's a whole lot better than trying to go to town meeting and changing the zoning bylaw, which is the only option, really. If the only other way to put a grocery store there is to go to town meeting and say, how about making an amendment to the use table?
In Wakefield, it's typically creating another overlay district is the way that seems to have been addressed. But
Same deal.
A use variance sounds like can be very useful, and I'm not an expert in this. but it sounds like it can be very useful if it's used and not challenged all the way up through an appellate court. So if it's granted and used, there will come a point where the appeal itself may become moot.
Yeah, I think that the statute was rewritten to say that the bylaw had to expressly allow consideration of use variances to give a neighbor a leg up if it doesn't. So, it's pretty easy to go to a case management conference with a judge at the land court and show them the bylaw, and it doesn't say anything about use variances. I mean, the judge knows what the judge has to do at that point. He has to invalidate the variance. And it's not a trial that gets the neighbor to that point. It's a motion to dismiss.
So okay, and I think that's really helpful information, just so that we can make the decision as a town, and that will fall through this process. As
Yeah.
do should the zoning board of appeals have the ability to make the use variances, the ability to grant them, which can be useful, but can also take up the time of the board as well. So it becomes a matter of that balance is what I'm
Yeah.
hearing.
And I'm not gun shy of a use variance. I think, when you go to Quincy, or if you go to Everett, or if you go to Haverhill, or if you go to another city that's, Revere, that's used to this kind of give and take, it's in every meeting of the ZBA kind of thing. And it's just a whole lot faster than going to city council on a zoning amendment. All right, so the planning board gets its own section on 10.5. There was no planning board mentioned before, other than the associate member section, which is right there in black. And I'm assuming that the planning board is site plan approval authority, and on some occasions they grant special permits. So your job description has been included. So the special permit section is notable principally for section 10.6.2, which are the criteria, and your criteria sit below it as a strikeout. So, requested use is essential and/or desirable to public convenience or welfare. I'm not sure that's a strong criterion. Undue traffic, we agree. Overload any public water, drainage, or sewer system or municipal system, that's fine. Impair the integrity or character of the district or adjoining districts, public health, convenience, or welfare. And your last one is character of the neighborhood. So I've relied on these 6 criteria for 35 years. We use them in Dedham when we did Legacy Place. That's probably the ultimate test that they've been put to. Social, economic, community needs, do we have enough of this, or is it something that we want to still consider? A good example is Tewksbury, Route 38 off of 495. You need another car dealership there, really? Maybe we've saturated that. Traffic flow and safety obviously speaks for itself. Adequacy of utilities, neighborhood character. Social structures are an interesting side line to that. So a great example is somebody who does a business out of their home. The kids are playing in the cul-de-sac and the little plastic cars with the basketball hoop, and now there's a lot of traffic coming because of the business in the neighborhood. It's going to change what happens in the houses. The kids are not going to be allowed out on the street anymore, and people are going to watch their kids out the kitchen window at that point. So it does have an impact on social structures. Natural environment includes everything from stormwater to noise, and fiscal impact's really an interesting thing to know in terms of what it's going to mean to the community. Right now, I'm helping a small town do a warehouse proposal that's probably going to add $600,000 to $800,000 a year in property taxes that will fund a lot of the small town's discretionary spending. So interesting thing to know. I've taken some of your procedures in 10.6.3 and moved them over to here. Conditions, again, this is a sushi list, but these are just things you could do. It's not meant to be all inclusive. Under referral, I've tried to make it clear that Concom, Board of Health, DPW, all get a copy of the application so that they can make some comments to the special permit granting authority. And then the plans, basically, unless otherwise provided by rule or regulation of the SPGA, would be the section, the next section, the site plan. So it doubles as a site plan and a special permit plan. And under the lapse provision, as we were talking about a minute ago, the lapse provision is no longer 1 year, it's 36 months. You can put 3 years there, it doesn't matter. In the site plan review section, I added a couple of criteria just to make it more precise in terms of what triggers site plan. So any new development, expansion, change, but I kept the districts that you mentioned, which would add 5 or more parking spaces, or any new development in the districts, which would involve the construction of X square feet of gross floor area. Because right now, I think you just said basically any new development. So I wanted it to be a little bit more clear. Under procedures, for reasons I'll explain in a minute, a public hearing should be held. And that's because the land court has held that if you're going to allow people to take a site plan decision directly to court under Chapter 48, Section 17, land court or superior court, the land court has ruled that in that event, you should have a public hearing. So a public hearing would create a record for the judge to be able to review. And it's the cost, at least in Judge Foster's mind, of being able to have a direct appeal to court. Right now, your appeal provision, let me get to it when we get there. So pre-application review, the site plan requirements, yours are kind of, yours are fine. I'm just showing you a different example, basically. And then the decision criteria are mine and new, yours are below it. We can mix and match if you want to keep some of the ones you already have, but they basically say the same things. There's a couple of provisions on performance guarantees. And here we come to the interesting news. The lapse provision is added and it's 3 years, much like the special permit lapse provision. And then the last and most important change is 10.7.13, which is a direct appeal to a court of competent jurisdiction. I do that for a number of different reasons. Number one, yours is an appeal to the Board of Appeals. With all due respect to the Board of Appeals, nothing suggests in the state law that they're the superior of the planning board. They're equal. So it's rare that you would have one board review another's work, especially where the planning board has developed an expertise in dealing with site plans and the Board of Appeals deals with them only when there's an appeal. I don't think that's a collegial approach. Not that there, necessarily would be trouble. The court decisions on site plan appeals in the absence of a direct appeal being prescribed by the bylaw are that the appeal comes when the building permit is issued or denied. Obviously, if I'm a guy who wants to build a widget factory and I get a site plan approval and I don't like some of the conditions, my building permit's going to be denied unless I completely reverse ground and comply with the site plan. But I'm appealing the site plan, so I'm clearly not going to do that. It could be 2 years before I take that step. And then the building commissioner's denial is the thing that triggers the appeal to the Board of Appeals. And then the Board of Appeals decision can go to court. But the Board of Appeals is clearly looking beyond the building inspector's denial, and he's gauging the decision of the planning board. So I started writing this 20 years ago. At first, I got a lot of pushback from the Attorney General's office that, you know, towns can't create court jurisdiction, but this has been reviewed 20 times now, and there's no problem with it. And it's just a lot better way to do it. Just go to court. Just take the whole thing to court. And this applies to the disgruntled applicant, and it applies to the disgruntled neighbor. Remember, site plan approval is, however, supposed to be fitting the use in, not denying it. So there's some special rules that apply to site plan, like, you know, you can't load the conditions up to, for all practical purposes, create a denial. Generally speaking, site plan is viewed by the judges, especially at the land court, as something to be conditioned but not denied. There are exceptions to that. An incomplete application, a use that's not allowed in the district, those certainly could be denied. But other than that, you know, it needs a lot of work. There's no mention of site plan review in the statute, except now there's a new mention in the bond provision that was just adopted. But that's the only place the words site plan review, site plan approval appear. And Canton, probably the first town to do site plan, has a case that goes back to the early 1970s. So, you know, the legislature's been told in infinite number of cases, by the land court especially, this is, why are you torturing us? Just adopt some basic rules here. And they've never done it. So it's all a creature of local rule. I'm just going to hit the highlights here, and then we can come back and address any questions. The site plan review for Dover Amendment uses. I think it's a better way to deal with churches, schools, and childcare facilities than handing the whole thing off to the building commissioner. Right now, the intake officer for Dover Amendment uses, particularly those three, is the commissioner. He's supposed to get it. And not only is the building commissioner supposed to decide whether the use qualifies, you know, is it primarily a religious purpose? That's the building commissioner's decision. Is it something that qualifies as a nonprofit educational use? That's the building commissioner's decision. Is it a child care center or a school-age child care program that has appropriate licensing forthcoming or actual from the state? He's got to check the paperwork. And then the second is, what reasonable regulations should we apply to this protected use? And the reasonable regulations are listed in the statute. Reasonably necessary regulations concerning the bulk and height of structures, determining yard sizes, lot area setbacks, open space parking, and building coverage requirements, if any. It's not an exclusive list. The court has said you can consider other things, but those are the words mentioned in the statute. So if the building inspector says, I don't like your proposed Dover Amendment use, you have to take him to the Board of Appeals, and you're already in a position where you need at least a majority for a finding and a supermajority if it's a reversal of an appeal of a building inspector's decision. That puts the applicant in an unfair position. And so a vote of the planning board on site plan approval is a simple majority. It makes the practice a whole lot easier. And not only that, the appeal would be directly to court. And then the last thing that I usually include in this section is reasonable accommodations under the federal disability laws. So there are certain uses, for example, facilities for recovering drug and alcohol abusers. If you're recovering, you are a person protected by federal disability laws, and you're entitled to certain civil rights, statutory conformance. Failure of the municipality to observe those niceties generally is very punitive. It's a quick trip to federal district court, and probably your insurance carrier is driving the car. So you really want to do this right. You don't want to mess it up. I've had cases all around you, Wilmington, Wenham, Andover, where the rules weren't clearly spelled out. People made mistakes, and you know, this tells you what you're supposed to do. And again, if you don't do it this way and put it in the hands of the ZBA, then the building commissioner is flying solo. And that's, neither here nor there, but if there's a mistake made, it's kind of easy to trace it back. I'd rather see a committee immediately get in touch with your lawyer and make sure you're guided through this process by competent counsel. So those are everybody's job description, especially in section 10. The last two are relatively recent additions. The Attorney General's office ran a symposium on disability law maybe 7 years ago. And since then, I've started putting in my bylaws the reasonable accommodation provision. And I think it's an important, it fills an important omission, because most lawyers, certainly most board members, zoning officials in town don't know what kind of trouble they can get into.
Fortunately, we do have a few people in this Zoom meeting that have expertise with this disabilities accommodations. So, and I'm seeing a few people that are smiling and nodding. That are aware of some of these issues, and your points are well taken. We also do have several facilities in Wakefield for substance abuse recovery and so forth, and
Yeah.
we want to make sure that we don't put ourselves into a place where those facilities are not getting the protections that they are afforded under federal and state law.
Yep. So that's a lot to chew in section 10. And you wanted to take a moment to look at it. Oh, I also added the design review provisions as section 10.10. I didn't change any of that.
Okay, a few comments. First, Mr. Hogan.
Attorney Bombrowski, thank you again for your overview. Unfortunately, not having received a copy of this in advance, it's very, very difficult to review it and have any intelligent feedback. So my feedback to Chairperson Lieber would be request on behalf of the Planning Board a copy of this section 10 as currently constituted, so we can review and internalize. Obviously, Mr. York is about to be on our board, and Mr. Knowles on the call as well, but I'm sure Mr. Spalding and Lowry would have a lot of feedback as it relates to this. I think we'd want to look at it in a form of our board in order to formulate whatever our initial feedback is going to be as it relates to this section.
Absolutely noted. I intend to take, now that we have received these documents, post them to the website. I will send the Word documents off to the other boards, as well as to Attorney McGrail, so that he can do the markups and so forth as well. So that I'll keep everyone in the loop, and the idea is to really keep our community informed as to the information that we have.
Jen, if you send me one email that has everybody's email on it, I can just use it as my template, and that'll take some pressure off of you to circulate it. I just bomb everybody with it the next time a memo is coming up.
The town has requested that we do things through the bylaw email address for most outbound, especially where some people don't necessarily want their email addresses fully public.
Okay, no problem.
I appreciate the willingness to take the load off, but for these pieces, I am going to encourage the direct communication with Mr. McGrail, Mr. Hogan, Planning Board as well, because we're not trying to hinder the communication with you by any means. Mr. McGrail.
Thank you, Mr. Chair. I concur with Planning Board Member Hogan. There's an incredible amount to digest, and section 1 and 10. I think the majority of the people that participated tonight, I know I can speak for myself, were prepared to deal with section 5 because that's what was posted and we had an opportunity to review that. So what I would respectfully request is for you to consider that your next meeting, we would have discussions on the 2 articles that were presented tonight that we didn't have an opportunity to adequately prepare for to make comment on. Just to keep this as an organized procedure, so we're not surprised at the next meeting that something else is popping up without us having a chance to appropriately comment on what's been presented to date.
Absolutely. Feedback is always welcome, and we will definitely be coming back to these sections.
That'd be
So
great.
it's probably not going to be at the next bylaw review committee meeting directly, but it will be at a subsequent meeting with Attorney Bobrowski so that we can go over the feedback in more depth
On those 2 articles,
on those 2
2
articles.
sections. Thank you, Mr. Chair.
Absolutely.
Appreciate that very
Absolutely.
much. Thank you.
Other feedback.
The next mailing will be, or email will be, the use table restructured and definitions, new definitions that are not currently covered by the bylaw. So just as a preview of who you might think about giving that information to.
The answer to that is the world.
Okay.
And so we have the invitation list for these meetings is quite extensive. We have been fortunate that there's a lot of people that have expressed interest, and we've seen even here, we've had quite a few people come in and out of the meeting. So great feedback, and yes, we will come back to all of these issues. Any other feedback on these sections? Mr. Noel?
Not on 1 and 10. When, Attorney Bobrowski, when do you expect this next memo with the reconstituted use table?
Depends on when we pick for the next meeting date.
Oh, okay. All right. Thanks.
As I did on this one, I usually get it out at least a week ahead, and that was the case for this. So this summer, my workload is going down, so it'll be 7 to 10 days in advance.
Councilperson Lieber, do we have line of sight of when your proposed next meeting on this topic is for the bylaw review committee?
So that's actually a great segue into the upcoming date. So the next meeting of the bylaw review is currently set for Monday, June 5th, because the third Monday in May is Monday, May 15th, which happens to be when we have town meeting. And by charter and by practice, we will much rather be at town meeting where we are both the planning board and the bylaw review are presenting articles so that we can get those reviewed, but not zoning articles, but related things. The last Monday in May happens to also be a holiday, Memorial Day. That brings us to the first Monday in June, which is June 5th. The next Monday after that, the way that the calendar works is June 19th, which is also a state and federal holiday, so we won't be able to meet on that day. That would bring it, we're getting hit by lots of holidays.
Juneteenth, yeah.
It is Juneteenth. So naturally, the next meeting would then be July 3rd, which is an impractical date to have a meeting. So I will convene with, and traditionally there are very few meetings in July and August for most municipal purposes, as people try to do this thing called vacation. That leads us into September. The first Monday in September happens, of course, to be a holiday, continuing with our tradition of falling on holidays. That brings us to September 18th, which would be the next meeting date on which to discuss bylaws. So that the short answer is we're looking for this particular purpose, probably September 18th.
You don't want to try, I don't know what your agenda is on the 5th. You don't want to try to squeeze one more in before we take that long a break?
There are some, we have the option and I'll leave this up to the bylaw review committee members that are on on this particular call. We have initially tried to alternate between the other bylaw topics that we're also responsible for covering, as well as zoning. But given the delay and the interest here, I have no problems putting the other items on a delay. That we don't have anything that is particularly urgent, and so we can certainly go ahead and continue with zoning because of the timing and the way the calendar works for the Monday, June 5th meeting. So thoughts for those of you on the bylaw review committee?
I agree with you, Dan. I think we should just keep the ball rolling.
I agree.
Okay, so that puts us to Monday, June 5th, 7 p.m. by Zoom. With the authorization that was given by the state, we can continue to use the Zoom meetings, which seem to be very effective. At some point, we will have the ability to do hybrid meetings, in which case, Attorney Bobrowski, you'll have the ability to come to Wakefield and sit in a room and still interact with people both in person and on Zoom. The tech for that is still in the process of being worked out in a more reliable way. We have had some success with it.
The good old days.
Whether it's good and whether it's old, that's all a matter of subjective opinion.
I'm going to put the 18th down for you too, just
So
because.
June 5th and September 18th,
Yeah,
I would recommend it as dates for these topics.
that'll be great because it'll give me, you know, I'll have the other two memos prepared for residential and non-residential stuff, and then we can do another meeting after the 18th in quick order because I'll already have the materials prepared for you. So
excellent, much appreciated. So
okay.
with that, we now have the next two meetings for the bylaw review committee set. Our annual town meeting, as a reminder, is in 2 weeks, Monday, May 15th, 7 p.m. in the Galvin Middle School. All members of all elected town meeting members, that does include those who serve on multiple boards. Mr. York, I'm looking at you. You get to do double duty at the town meeting, but we are actually all required to be at the town meeting. And so we have the ability to answer questions and give opinions. So at that town meeting, this particular committee has 4 items that are directly up. There are 2 additional articles on the town warrant. Just to bring your attention to those, I sent an email out. If anyone has a desire to have further feedback on it, one of those is sponsored by the planning board with our input that I think is an excellent bylaw on street numbering and street naming. And then the other one, it was proposed by the town council, and that came up in the end of March pretty quickly. If anyone would like to have a meeting and discuss that in more depth, please send me a note and we can certainly schedule a meeting for either earlier on Monday, May 15th, or we can find some time before that if you review that particular article as well. So with that, anything else?
No, I look forward to seeing you in a month, plus or minus. And
if you wish to watch a town meeting that is going to be hopefully not have too much of actual animosity at the meeting, I expect this one should go pretty well. You're welcome to watch it. It is available online, or you can of course come in. It is public meeting. Come in person to Wakefield. You know, it's always a delight if you want to have nothing better to do in 2 weeks on a Monday evening, because that's where we will all be.
no, my Concord town meeting is on night 3 tonight, so maybe I'll pay the penance and come to yours. We'll see.
So that happens to be the reason why by town council Mullen is not at tonight's meeting. One of the other towns where he's working has town meeting tonight.
Yeah.
I definitely don't miss those Concord town meetings. 4 days, 3 days, craziness.
How about the one where we banned bottled water and
Oh, I was there.
leashed,
Yeah,
and
that was a good
leashed
one.
cats? Remember the cat
Oh,
leash?
the cat leash law was a good one too.
Yeah.
There's a bunch of good ones.
No
I
comment.
think the consent calendar had like 40 articles on it, and then they just gab on like 5 or 6 of them. Good.
That sounds like keeps things interesting.
Yeah.
So, okay. Without anything further, it's 9:27 and need to actually, it looks like we've temporarily lost our recorder. I'll take the note on the motion to adjourn. We have a motion to adjourn.
So moved.
Okay, and was faster on the mic. Do we have a second?
Second.
Tim is seconding. Okay, with that, at the moment, we're down to 4 members just due to technology. So with that, Joe,
Yes.
Tim,
Yes.
Ann,
Yes.
Kevin, and myself. So we've got 5 members on. With that, meeting adjourned 9:28. I will send Catherine a note, so she can add it to the minutes. And Catherine is joining us. The power of technology. So Catherine, welcome back. We actually had just taken a motion to adjourn at 9:28. So with that, the meeting is going to be formally adjourned. Next meetings will be on Monday, June 5th and September 18th, just due to the way the calendar works. So with that, thank you, everyone. It's been a long evening. Really appreciate all of the time. I will send out the additional information now that we have those 3 files, I will send those out as well to all of the members, of the Bylaw Review Committee, as well as Planning Board and Attorney McGrail, so that way we can all mark them up. And in that, if anyone wants to send that directly to Mr. Bobrowski, you're welcome to do that. You're also welcome to send it to me. I can forward it on as well. Thank you very much. Really appreciate everyone's time and attention and feedback this evening. Really good meeting.
Thank you, Dan.
Thank you. Have a good night.